Hello, everyone, and welcome to today's episode of Beyond the Bank. A critical aspect of wealth management is the transition of wealth from one generation to the next. And today's guest has built her career in the fascinating and dynamic field of estate mediation and litigation. Felice Kirsh is a partner in the firm of Schnurr, Kirsh, Oelbaum, Tator, a leading Canadian law firm focused on all aspects of estate disputes. A graduate of Osgoode Hall Law School, Felice is a sought-after speaker and writer in the legal profession and has been recognized by her peers as one of the best lawyers in Canada every year since 2008 in the specialty area of estates and trusts. Welcome, Felice. Thank you so much for joining me today.
Thank you for having me.
So let's jump right in. So, Felice, you graduated from Osgoode Hall, where I suspect you took classes in litigation and in wills and trusts. But how from there did you find your way to focusing your career on the niche of estate litigation?
So it was really actually a fluke that I ended up in estate litigation. I articled at a large firm and did not get asked back, then was looking for a job way back in the mid-1980s and found a job at a boutique firm that did a little bit of everything. And I decided when I was doing a little bit of everything, all kinds of litigation, that I probably would never be good at anything because it was so wide. So I just kind of wanted to get into some specific area of litigation. And I didn't have my sights set on estate litigation. It's a very niche area and I didn't know anything about it. And most people don't. But I got my next job where I was doing estate litigation and franchise law, which is a very odd combination. With the idea that I'd specialize in estate litigation. And I've been doing that since about 1987.
Wow. So got into it by happenstance, really, but clearly you've excelled at it and loved it. Now when you're speaking to someone, say in law school or something like that, what would be your elevator pitch for estate litigation as an area for a young lawyer to focus on?
You know, I think first you have to have the litigation skills, and then you have to decide whether you like personal litigation, which would be like family litigation and estate litigation and some other kinds, or whether you want the more corporate litigation, which is acting on behalf of, companies in sort of large disputes. I prefer more, I would say, hands-on, interesting litigation, maybe helping people as opposed to helping companies. And so if you want something that's, in my view, very challenging, but also very rewarding, that would be estate litigation and certainly other areas of litigation as well.
That's really so very interesting. So as we've discussed, our listeners today are largely wealth advisors. So perhaps we could set the stage by describing what an estate conflict process might look like. What are some paths that people take to find themselves in your office, and where might it go from there?
Sure. So there's all kinds of disputes surrounding estates and frankly also surrounding power of attorney issues that end up in my office. And how they get here, is sometimes I'll say too early and sometimes too late. But, something goes wrong in an estate or somebody doesn't trust somebody. Often the beneficiaries don't trust the estate trustee, or, you don't trust your brother or you don't trust your sister, or it's often the second wife, and just everyday things like that make people seek out some estate litigation advice because sometimes they think there will be a dispute. The smart ones think, let's hear about the dispute. I think one could be coming, but hopefully not. And, sometimes they come literally 2 weeks. Sometimes clients come literally 2 weeks after somebody dies, which I think is often, not always, but often too early. And sometimes they come, 5 years later, which is often creates another problem with respect to, evidentiary issues, sometimes Limitation Act issues. So, all kinds. I mean, I'm more than happy to go into some specific types of cases I see, but when the client comes in, they don't know the specific case they have. They can't frame it in a legal way. They just say, here's my problem. And then of course It's up to the lawyers to say, oh yeah, that's a case we can deal with. That has a resolution, or, that doesn't have a resolution, or your case looks too weak to even try to get some kind of resolution in a formal process. But, it's everyday people, it's sophisticated people, it's unsophisticated people. The problems are the same, regardless, you can have the same estate litigation problem on a $200,000 estate as you do on a, $2 million estate or a $20
Mm-hmm.
million estate.
Mm-hmm.
Um, the problem is not often, it doesn't equate to the amount of money in dispute, but of course the legal fees have to equate to the amount of money in dispute.
Yeah,
So, I've dealt with all kinds of small, medium, and large disputes, and, resolving them is often, just as hard in a small dispute as it is in a large dispute.
of course. Wow, that's just also very interesting, and I have so many questions from there. Going back to your comment that 2 weeks after the death is, maybe too early. 5 years after the death is too late. Starting with the too early bit, what sorts of things would you say to those clients in terms of why it's too early, and if when they might return to your office?
Yeah, so I always give this example, somebody hears that, if you're the executor, you should secure the assets of the estate. They read that in the paper, they heard that from a friend. So I'll give you the typical example. The second parent dies, there's three children. They've always had keys. All of them have had keys to their, let's call it, father's house.
Mm-hmm.
And one of them, for whatever reason, was appointed executor, not the other two. And that one hears from their friend or whatever, oh my gosh, I better secure the house. So what do? They change the lock without telling their brother and sister.
Okay.
And the optics of that leads the brother and sister to come to a lawyer very often and say, oh my God, I wanted to go to my father's house and see, I don't know what, and I can't get in. And who knows what my brother did? He might have taken all the jewelry. He might have taken the money under the bed. I mean, obviously I've heard it all. And sometimes I say, you know what, why don't you have a discussion with him and see what it's all about before everybody starts running to lawyers? As soon as people run to lawyers, it's a bit of a sinking ship, for sure, as far as fees go. And, people start putting out positions. And
Mm-hmm.
it doesn't often happen, but I always, suggest to people, because they have a relationship, they are siblings, their children are cousins, that if you
Mm-hmm.
can try to get on a better footing, try to do so, because you're not, it's not like commercial litigation where you never have to see the person anymore. You don't really care. It's not personal injury litigation where you're suing an insurance company. You have no connection with them. This
Yeah.
is a family in a high conflict and very emotional situation. So I like to try as much as I can. Listen, it often doesn't work. That's why they're in litigation. But I like to temper it down. I don't like to fan the flames, which frankly is much easier. It's much easier to fan the flames of a
Sure.
person who comes in your office and is mad, but I like to put down. So, and then sometimes they just come, you know, really early because there's nothing wrong, but they're worried there could be something wrong. So I just say, why don't you wait 2 months
Mm-hmm.
and then come back and let's see, really tell me what the issues are, or maybe things have been like little things, who's paying for the funeral when the estate account hasn't been opened. These things can all be resolved. You don't need lawyers for those things.
Right. Right. And the question of too late, then it's just sort of 3-4 years after the fact. A neighbor tells them they might have not got what they should, or something like that.
Yeah, too late becomes an issue of evidence, right? So if you're a beneficiary of an estate and you haven't got an accounting and you should have got one, every couple of years, or if it's an ongoing estate or you didn't get one, like it's hard for people don't have sometimes receipts or what we call voucher material for all kinds of things. They didn't know they should keep it, so they didn't keep it. And then you can't recreate documents that you don't have. Sometimes we have estates going back many, many years. And, I
Mm-hmm.
think generally, um, you know, banks keep records now for 7 years. So in those kinds of cases, it becomes very hard to recreate the facts. And when it's not an accounting dispute, but maybe a will challenge or dependent support claim or these other cases, people's memories are not that good 5 years later. So, you have, and then witnesses disappear. I don't mean disappear into thin air, but we can't find them. They might have moved, that kind of thing. So, and then generally the limitation period really for all of civil litigation is 2 years from the cause of action, which in the cases I do is generally, but not always, there's exceptions, the date of death. So you don't want to come in 5 years later because you might have a limitation issue.
Right. Right. Very interesting. When they come in and it's my sister's locked me out or that sort of thing. So early on, do you get the sense, Felice, that in many of those cases that there was issues in the relationships prior to the death? That the changing of the lock wasn't a sudden change from happy to going to see you?
My experience and is that the families that are fighting, the ones that I see in estate litigation, have always been fighting. They've been fighting for 10, 20, or 30 years. Or if they haven't been fighting, there's been this underscore of rivalry or disagreement, and on the second parent's death it just comes to the forefront, right? They hold it together when their parents are there, even they
Okay.
hold it together on the first parent's death, but on the second parent's death, no holds barred, and we can now discuss everything that could have ever gone wrong in their life. So
I see.
I will also add, for the listeners, that my experience is a bit jaded because I'm dealing with the worst cases. I'm dealing with estate litigation. And I think that, doesn't matter, 95, 99% of people in Ontario and Canada,
Hmm.
someone in their family dies and they all get along and they see the terms of the will and everything's fine and they never need a lawyer like me. But in the cases that I see, some are easier than others, but they are high conflict, highly emotional. People feel really hard done by. They
Hmm.
really want to be heard. They want their story told. Um, and and so it kind of takes on a life of its own beyond the legal part of it.
Yeah. Well, it's just so very helpful that you say this, and sure, of course, you'd only see the families that are in conflict, but for again the listeners, it makes me think that they could view estate planning and discussions with their client far broader than simply the planning documents and all of that. If they're aware, as many wealth advisors are, that the family is a conflict prone family. I mean, they might see it in the investment discussions, all of that. There's many different ways in which families can look for conflict resolution or mediated discussions, whether it's with a psychotherapist or whether it's with a lawyer before the illness, before the death, the pre-planning. We tend to think of it as very objective, the documents, but from what you're saying, there's also being attuned to the conflict.
And I think, I'm of two views about that because I know, there's this, I don't know if it's a trend or there's this body of thinking that you should have these family meetings and you should tell everybody what you're going to do. And let's just give a simple example. And if you're giving, let's do the second death of the parent again. And if you're
Yeah.
giving one child more money because they've helped you, et cetera, then you should disclose that so that everybody knows it and it's not a shock. And I understand that thinking. I totally respect it and understand it. But I also see the contrary, which is a will is a private document.
Right.
It's just the person's document. It's not a contract between two people or more. And it's your private document. And that's your last wishes.
Yeah,
And it's pretty
that's right.
hard to confront somebody and say, by the way, I was going to do it, 33, 33, 33, but son A really helped me a lot and I'm going to give him, 40 and I'm going to divide the other or whatever.
Hmm.
And that's not a discussion people want to have. So, and
And why should they, to your point, if they
right.
don't want to?
And it's
Yeah.
their private document. So I feel like,
And it's their wealth.
yeah, yeah. And why do adult children have to know all these things? And I think the parent thinks like, I'm going to make my decision. I don't want any people knocking on my door telling me what they think. And oh, because my brother stayed there, well, don't you remember that I did this for you last time you were sick? Like they don't want that in their life, the last months or years or any amount of time. So I'm totally
Hmm.
sympathetic to the, testator that is not going to tell anybody anything. And I don't know that it's always a good idea to have these family meetings. Although I know that it's people like it and it is advised often to do it. I don't know if it's always the best thing in every circumstances. And I'm more not more concerned, but I am very concerned about the person's privacy and their
Hmm.
ability. This is the only document you write in your life it's yours, right? Otherwise, what are we doing? We're doing contracts, so we're negotiating between two people or
Right.
more. A will is your own document expressing your wishes when you die. Why does everybody have to have input into that? I mean, you
Yeah.
have your lawyer, and the lawyer should be giving you some good advice. But why do you need all this other input? I don't know. I feel like it's a lot of pressure on people.
Yeah, exactly. And I mean, in Canada, I mean, testamentary freedom is largely there. Certainly, there's, some obligations for a dependent child, or like, different things, obviously. But I really like what you're saying there. It makes a lot of sense. From that same perspective, then, what are your thoughts on documents that are left with the will, a letter explaining the 33, 33, 33, or is it the same view that it's really nobody's business and I don't need to write a letter?
Um, the problem with the letters or the memos, and I is there's sort of two lines of case law, and I forget the exact words, whether that is part of the will or it's
Ah,
not part of the will, whether it
right.
can be relied on as to show the intent or where it can't be relied on. So, because I like certainty,
Yes.
I would rather have a sentence right in the will as
Sure.
opposed to it in a different document. Like, I
Yeah.
don't mind if someone says, I've got tons of jewelry and we should distribute it as per Schedule A. That's a different kind of thing. But a document that's going to say why a person made an unequal distribution or an unexpected distribution, I'd rather have literally two lines in the will, which explains it, because there it's out in the open and there's not this
Yeah.
whole evidentiary issue when you go to court about whether that is their intent. Is it a testamentary in nature? What is that document? There's a lot of case law on it. It's confusing.
Mhm.
So that's what I would do, but it's all about, in my view, making it very simple, not 10 paragraphs as to why the testator is doing this, but like two sentences.
Just confirming that, yeah, no, this was no mistake. This is what I wanted. Yeah.
Yeah.
So moving then to substantive issues that you see, capacity, undue influence, subsequent spouses, kids who haven't left home, the list goes on. Are there ones, three, four that come to mind as, oh my goodness, and any given Wednesday, it's like you've already seen three of them?
Yeah. Well, I think your examples are the top ones. So, a significant portion of my practice deals with will challenges. So, for your listeners to have sort of a little recap here, but basically, people, subject to a couple exceptions, which you mentioned, people are free in Canada to do whatever they want in their will. The exceptions have to do with the spouse in certain circumstances and dependents in certain circumstances. But otherwise, people have complete testamentary freedom. And the only way that you can, I'm going to speak specifically now more about Ontario because I
Mm-hmm.
think the law is a little different in the West. The only way you can successfully set aside a will is to show that the person is on the grounds of lack of testamentary capacity or undue influence, or in the very rare circumstances, forgery. And I'm not going to talk about forgery, that's a whole other thing, but in lack of testamentary capacity, it is very difficult. It's a real gray area.
Mm-hmm.
As people get older, their cognitive abilities decline. Sometimes, not always. That decline can be gradual. You can have good days and bad days. And I haven't had a case yet where we're dealing with this where it's so obvious one way or the other. Because if it
Uh,
was so obvious one way or the other, it probably wouldn't be a case.
right.
So in those cases, I can tell you that the most important evidence is the evidence of the neutral parties. It's not the evidence of the daughter who says it's valid or the son who says it's not valid, because they're
Mm-hmm.
parties and they want a particular outcome. So their evidence is already biased.
Yeah.
So the most important witnesses on these cases are the lawyer who drafted the will. Did he or she take good notes? Did they canvass everything?
Mm-hmm.
Do they speak the same language? Was the major beneficiary in the room, which should never be? It's a big no-no. All these kinds of things. So and did they create a good file? I mean, sometimes I think I have a bad case just initially, and then I see the lawyer's file, and my case has gotten better because the
Mm-hmm.
lawyer didn't do a good job. And then the converse is true. The other important witnesses are, of course, all the medical evidence.
Mm-hmm.
Often people are, they certainly see doctors, but in later life might be in and out of the hospital. So all the nursing records, doctors' records, test results, all of that. And then dealing specifically with financial planners, they often have files
Mm-hmm.
which can lead to a conclusion one way or the other way, whether the person had capacity or whether the person doesn't have capacity. So sometimes people have been to financial planners for 10, 20 years, and the people really know them that well, and that person's evidence might be very helpful to one side of the case, because they can say, yes, I knew Mr. A for 20 years, and he always came in by himself. He was very careful. He asked good questions, and the last time I saw him, which was 4 months before he died, he still asked good questions, and he was really good. Or they can be saying the opposite, or you can have a financial planner that has been the son's financial planner for 20 years. And in
Mm-hmm.
the last year of the person's life, the son says, oh, here's my dad. He's going to move all his assets to you, and here's what we want to do. And the financial planner takes their instructions from the son. That is a big, big red flag.
Right. Right. Um, I enjoy reading the cases on testamentary capacity because often the judges are very empathetic. I don't remember the case name, but there was one where the judge basically said, look, the deceased was a cancer patient. Of course, he had good days and he had bad days. And I'm sure in that case that the judge held that there was capacity there. Can you sort of briefly talk about the different things that the court expects a person to have known for, their
So,
assets, who they
sure.
benefit, so on?
So I'm going to give you the test for capacity, which is from an old English case called,
Hmm.
I think, Banks and Goodfellow. It's easy for me to say it. Of course, we could talk about what it
What it
means
all
for
means?
2 hours, but let's talk about what the test is. The test is a three-part test. One is you have to understand the nature of your assets. So you don't have to know that you have $4,325,000. Nobody knows exactly, but you have to you have to be able to say, look, I have a house and it's worth $2 million, and then I have another $2 million investments. Some of it's in this and that. And so the nature and extent of your assets you have to understand. You have to understand who, with, like, I think they call it like the natural affection of your bounty or something like that, some kind of old English thing. But basically what it means is who's around you. Like, oh, I have two kids. You don't have to like them. You don't have to give them anything, but you kind of have to know that you have two kids,
They're
you have
there,
a
yeah.
spouse,
Hmm.
that, right? And then the third thing you have to know, which is usually doesn't come into play, is that what you're doing when you're signing your will is that you're signing a will. You're not
Yeah.
signing a contract. You have to know, oh, I'm disposing of my assets. So those are the three factors, but it's really the first two that come into play. And really, it's all about, it's all about the evidence around you. Like, for instance, we have people who, like older people, who play cards. So I think,
Hmm.
they play cards, and they play cards right up till, 2 months before they die. And that's great. Well, I would say someone who can play cards
Hmm.
and understand all the different rules, because I don't play cards, it's too hard for me. To me, would show capacity, right? That's a thing that
Yeah.
shows capacity. Does the person drive? Okay, you have to have some amount of capacity to drive. Is the person on the other side, is the person completely housebound, and they're reliant on everybody else to give them their news, and they really don't know what's going on, not only in sort of the outside world, but kind of beyond their four doors. And then just moving along to undue influence. So
Hmm.
undue influence usually goes along with testamentary capacity, because there's hardly a case where somebody whose cognitive, it just kind of goes together. If your cognitive ability is decreasing, you are
Hmm.
more susceptible to influence. So
Yeah.
we always plead them together.
Hmm.
We always deal with them together, or mostly always. There's a big difference for the burden of proof, and this is, I think, important, which is that the burden of proof on capacity is on the person propounding the will, the people who want the will to be valid. Whereas the burden of proof on undue influence is on the people challenging the will, which is very hard, because it's very hard. People who are unduly influencing their parent
Hmm.
and saying, if you don't put me in the will for 80%, I'm not going to get you dinner every night.
Hmm.
Nobody has that evidence, because that person's not saying it in front of everybody. So So it's hard to get the evidence of undue influence. Capacity is in a way of like a case just on undue influence is few and far between. But just to show you how they interface, um, it's the typical situation where maybe one child is becoming more of the caregiver, right? That one
Mm-hmm.
child is bringing the meals. That one child is taking them to appointments. The other two are around, but they're just not doing as much. So then maybe that child starts to get a few gifts because the parent says, "Oh, you took me here, you took me there. I see your son wants to take some piano lessons. You don't have a piano. Here's $10,000 for a piano."
Mm-hmm.
And that's kind of how it starts. And then all of a sudden it gets to the will and that person's getting more, which might be fine or not fine. But as the person's cognitive ability goes down, maybe the ability to influence goes up, and
Sure.
they're always intertwined.
Yeah, the ability to influence and, proximity. If the other two children are fictional children that you mentioned are living in California and Texas,
Yeah.
and the other child is in Toronto, um, and going back to our earlier discussion about this is a very private will, and a person can choose to leave 40% to one child and split the other. So in this case, say there is cognitive decline, every normal aging sort of thing, but the individual, the elderly individual, is thinking, this child has helped me so much, I would like to leave them 40%. What are your thoughts then on that individual, or perhaps even the caregiving child, making sure that they're, or not, I guess there's no way to make sure, but making it a reduced probability that there would be a claim on testamentary capacity and undue influence? Is it
You know,
legal advice at the time?
that the person, it's really up to the testator, right?
Yeah,
It's up to the testator to go to a good lawyer,
yeah,
to go to a lawyer that speaks their language. I've had the number of cases of somebody going to a lawyer who doesn't speak their language, and
yes.
has it been interpreted? Who interpreted it? Well, if the son interpreted it, that's not very good. If
Oh,
the receptionist came in and interpreted, then that's okay. So that's really where the lawyer has to do a good job. Like in some situations, lawyers actually get capacity assessments and they have it in their file. And sometimes some lawyers have even videoed people, and so they can show that if they're worried that this could be a problem. But it's not really, that the child who's benefiting to try to do that, all they can do is really suggest a lawyer and then stay out of the picture. Because the more,
yes.
and when I say stay out of the picture, it's not that easy, because even driving them to the
Right.
lawyer's office, I can make a whole
Sounds
thing about
suspicious.
driving. Oh, you drove them, and then you went upstairs, and then you sat in the lobby, and then you took them home. And of course, sometimes I say, in certain, and I don't want to at all like not think that older people can't make their own decisions, but in the kinds of cases that I see with older people, like
Hmm.
sometimes I say they're only as good as the last person who put an idea in their head.
Hmm.
So if your son is taking you and telling you everything, and bothering you, and then you go into the lawyer's office and the son is still there, did you sure you said that? And some lawyers are not as careful as others. Some lawyers, for instance, will have the son come in even just to say hello, but like the older people are saying, "Oh my God, I better put this son in for a lot because he took me here. He's with me all the time. He's going to ask me what I did," and they're vulnerable and they get scared.
Yes.
So it, I guess like the real moral of the story is to do a will. The younger you are, the better. I don't mean you can't. You should, of course, look at your will every 5 years. We always say, and you can always revise it. But
Hmm.
when you do a will when you're in the hospital, and then you pass away a little bit later, those are the ones that become more suspicious. You have all kinds of wills that are signed in the hospital. I was once called when I was long, long ago by, I can't remember, a nephew or son, and I went to the hospital, and the nephew or son was not in the room, and I asked the person questions. It was a woman, and she said to me something like, "Well, I'm going to put you in the will." So like right then
Oh,
and
yeah.
there, I knew that that's not a will I was going to draft, and I don't really draft wills. That was sort of way back. So it's hard for the children, especially the child who wants the will changed or something.
Yeah.
It's hard for them to make the evidence. It's really not for them to do it because it's going to look bad for them.
Right. So fascinating. Really could talk about this the entire session here. But moving on to subsequent spouses, I would think that is this also an area in which there are disputes between the stepchildren and the subsequent spouse that's surviving. Any
There are
thoughts on
huge,
this?
huge, huge disputes. It's always the second wife. I don't really think I've ever had a case where the second husband was the
Okay.
person suing the estate. It always seems to be the second wife. Maybe it's because women outlive men generally. I don't know. I think there's this, kind of attitude of some adult children. Again, I'm biased. I only see the worst cases that, it's all good and great. We're really happy my dad has this new common law spouse. It's great. We don't have to take care of my dad. This is fantastic. 10 years, 15 years. Sometimes the second spouse is a longer situation than the first spouse. But
Hmm.
then, the will provides something for the second spouse, which under dependent support cases it should, and or it doesn't provide enough and the second spouse makes a claim and the children are, no, you don't deserve it, etc., etc. Second spouses and children is a big area of estate litigation.
So tough question, I think. But what do people get wrong then?
Well,
What are the things
yeah.
that?
So I'm going to say something that a lot of people, a lot of lawyers and probably planners don't agree with, but I think what a lot of people do in wills for a second spouse is they set up a life interest for their second spouse. So they say,
Mhm.
um, you can live in my house for the remainder of your life, and upon your death, the proceeds will go to my three children. Um, and I don't like, and a lot of people disagree with me. I don't like putting people together in sort of a legal relationship when they don't like each other in the first place. So I prefer
Mhm.
when the second spouse is given X dollars up front and they
Mhm.
each go their own way. Now, people
Sure.
don't like that because the children don't want to see the second spouse getting, let's just make an example, getting $1 million up front because she could die 2 years from now and she didn't need the $1 million. And that's the thinking, right? So people think, well, let's give her a life interest. She can live on the income from the estate. She can stay in the house. And when she dies, we'll still get the house. But the problem is, as I said, you're keeping people together. And it's the same thing as spousal support. You're putting together people in a legal relationship that don't
Yeah.
want to be together.
Yeah.
I also say in the case of the second spouse and what I do is really the kids are sitting around waiting for the second spouse to die.
Mhm. Yes.
That's not a good thing.
That's not a good thing.
It's a terrible thing, right? Because they're not, and it's often the children who are the estate trustees. And so in a typical situation, let's say the wife is entitled to income
Mhm.
and there's the power to encroach on capital. So the wife
Yeah.
says, I need to put a new roof on this house, or I need to, I'd like to go on a vacation. My asthma is bothering me. I'd like to go to Arizona. I'd like to have $10,000. And it's, I think, very demeaning to have to go to your husband's children and say, can I have that $10,000? And then they say, oh, well, you got $10,000 6 months ago for this and that. Like, I think it's very demeaning for the
Mhm.
spouse. And it's a lot of pressure on these state trustees. And it can be a job that can last for 10 or 20 years.
Mhm.
I don't, I wouldn't want to be an estate trustee in these circumstances. It's really, really hard. I think that from lawyers, from planners, there's a tendency to kind of make things a bit more complicated than they have to be. I admit that I'm running uphill here against what a lot of people think,
Mhm.
but my experience tells me the simpler the better. Separate the parties, let them go on their way, and you
Yeah.
can't rule from the grave. You cannot predict everything that could possibly happen to your family. So just make it simple, make it the best you can.
Yeah. Well, it strikes me. I mean, the estate planning I did was many years ago, and even then there was a sense that sort of it was very quite old-fashioned planning. Whether it was the spouse from the original spouse, husband dies, and the wife and the mother of the children still gets a life interest. I mean, that was really old-fashioned. But now hearing you say that for second spouses or third spouses, the life interest is still a thing in planning. It this isn't really a question. It's more just a comment that, to your point, it seems very old fashioned
Yeah,
and demeaning. And since you say that isn't the second husband usually getting these trusts, it does seem like an odd way to go.
right. And what happens when these cases go to mediation, all these cases, what happens is you end up saying to your client, let's say I'm representing the second spouse, and I'm just going to make up numbers, do you want $10,000 every month for the rest of your life, or do you want $400,000 now? And then you have to get into all these things about your life expectancy and all that.
Hmm.
And I don't really like it. I like when I'm on the side of the person, I like to I tell my clients to take their money and run. Like,
Yeah.
take their money, you be in charge of your own money. If you
Right.
can't spend it properly, that's your problem.
Yes.
But don't be tied together for the next 10 or 20 years. And there's estate trustee fees every year. There's tax returns to be filed every year. You've created an entity, a legal entity, the estate, that's
Hmm.
going on for as long as the person, lives.
Right. Right. Very complicated. So let's move on then to settlement, and maybe before asking about settlement, just generally speaking, how it goes from that first meeting. The client hasn't come in too early or too late. It's perfect like Goldilocks, and they're in front of you. There is a claim. How do you start to paint the picture for how long this is going to go and what your fees might look like?
Okay, very good question. So I would say that, my practice is to tell clients right from the start that the truth is, which is that most of these cases, all civil litigation in Ontario, but I'll just stick to estate litigation,
Hmm.
95%, 90%, whatever, settle. They never
Hmm.
go to a full trial. That doesn't mean there can't be some what we call motions in the middle or some kind of contested proceeding, but they don't go to a final determination. And the reason generally is because it takes too long and it's too expensive. So right from the beginning, I think you have to gear your clients towards resolution. They're not ready for it. They're for sure not, but you have to keep legal fees in mind, and you have to understand what's happening. And I'll give you an example that always comes up. So a big source of controversy is estate trustee compensation.
Okay.
So if you're a 25% beneficiary and the estate trustee is claiming $100,000, people have to get a handle on, for every dollar you reduce it by, you're only getting 20, that's only helping you by 25%, 25 cents. And
Hmm.
people don't understand that. They just see a big number and they say, "Oh my God, my brother's claiming $100,000 and we should get it down to 50." But that's only the savings of 25% to each person.
Yeah.
So I'm always trying to gear people towards resolution. They're not ready to resolve at the beginning. And the second part of your question is with respect to a fee estimate, which is a totally good question people should ask, and they often do ask me. And even if they don't ask me, I like to give it. And
Hmm.
all I can say is what my hourly rate is.
Hmm.
I sometimes can ballpark if we have some pleadings and there's not too much commotion in the middle and everybody's cooperating and we get
Hmm.
to mediation, it will be this much. But that's subject to change if we can't get production orders, if everything is controversy. And you know, I think that two reasonable lawyers can probably solve most cases. It maybe some people will disagree with me and all that, but it's often the clients. It really is. And I see that because I'm also a mediator. I do a lot of
Yeah.
mediations, and mostly the lawyers know that this is not worth it, that there is no, I tell clients there's no certainty in court. Like, your story is good, you have a lot of good points, but I
Right.
tell them, I've seen many cases, and let's say there's 100 facts in every case.
Yes.
I've never seen one where all the facts are going my way. Not one. There's never been such a case. So be careful because, in some cases, like a will challenge, it's all or nothing. You have a lot to lose. It's not like a car accident
Right.
where a judge can say, this, the pedestrian was 30% responsible. This car was 15% responsible. The bus was, I can't do the math, was whatever part
Yeah.
responsible. If you lose a will challenge, you lose a will
The
challenge. If
will
you
is
win, it's all
upheld
great.
or right. Yeah. There's no gray area.
Yes.
That's a good point.
Yeah. So with respect settlement and resolution for probably the last, I think, 20 years or so.
Hmm.
Mediation is mandatory in Toronto and a few other areas in Ontario, but mostly everybody does it. And that's where most cases settle, if not before. And it's a really good thing for clients because they can tell their story in front of a neutral person, and
Hmm.
you can get a resolution which is creative, because sometimes there can be a win-win, but there's no win-win in court. So sometimes one person wants the house and one person wants the cash, and it's okay. Or sometimes people can agree on something even though legally it's not going to work that way because it's all or nothing. So mediation is a time to be creative, a time for the clients to have their day in court without being in court, without the rules of evidence.
Yeah.
I like to choose a mediator who has expertise in this area of law. I like an active mediator. I don't want to just like go back and forth with offers. I like someone to tell me, like, Felice, you know, I don't think that argument is correct, and let's rethink this, right?
Right.
So that's where most estate litigation goes, and as I said, generally all settles before mediation, at mediation, after mediation. There's so many obstacles to getting to trial. You have pre-trials, you have judicial mediations. I have cases where we've gone 4 times that you can't get a trial date that fast, and it's incredibly expensive.
Right. I'm curious about something you said, Felice, when you said at the very beginning or in the first couple of meetings with clients, they're not ready for a resolution. I would think that when they understand the scope of legal fees and the rates and so on, that they would be excited about the possibility of, Ontario and other jurisdictions having mediation and really being proactive about it. What is holding them back from being, as you said, ready for it?
They're too angry and they haven't
Oh,
been heard.
okay.
So they need they need some letters going back and forth, which says, your client, da 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 da, and then they need the
Oh,
story heard. They
okay.
and they need to see how expensive a lawyer is. They're not ready. There's lots of cases that I can probably tell quickly where it's going to end, but
Okay.
they're not ready to hear that. They're not ready to see the end because, you know, it's too soon after the person's death. They haven't had the grieving process. They're too angry with the other side, whoever that is,
Hmm.
and they haven't told their story. They want to be heard. And, good mediators can really do that. I've seen so many mediators where they take the time to say to the client, just something like this, like, that is wonderful that you took care of your father for the last 5 years, and
Right.
nothing is going to take that away from you. That,
Right.
like, full stop.
That must mean a
But
lot to clients to hear that.
now we have this issue here. And,
Yep.
and I also, I say to clients, like, it, nothing is going to change the way your brother or sister thinks. Like, no court, if people lose at court, they blame the judge, or sometimes
Hmm.
they blame the lawyers. Like, people don't change their mind. I've never seen somebody say, you know what? Oh my gosh. You know what? My brother really was a great guy. I should have thanked him all the years. I've never seen that.
Right. Right. That's very interesting. You mentioned, I know you're a mediator, and you mentioned the thought process you go through to choose a mediator. So, do you and your fellow mediators sort of switch roles? In some cases you're a litigator and people approach you to run the whole file, but then you retain a mediator. How does that process work?
Well, I mostly am the lawyer on files, but I also
Yeah,
do mediations. But many retired judges are mediators, or many retired practitioners are mediators. So not
I see.
everybody is in active practice and does mediation. Many
I,
do, like, have the retired or the retired judges. But, you know, generally the lawyers pick the mediator. So I will confer with the lawyer on the other side. It's almost never controversial. We always sort of come up with the same few names.
yep.
Some are more expensive than others, so it might depend on how much is at stake. Sometimes I think that my clients would benefit from a retired judge, because I would like to be able to say to them, okay, here's what Justice so and so says about your case. That could have been your judge. I mean, not now because, of course, they're retired. So think
Right.
about that. Some people
Oh, the
are,
credibility issue is
yes, some
strong. Yeah.
people need that retired judge. some people need a woman. Some people don't want to have a woman. Like there's a lot of a lot of
Sure.
dynamics, a lot of things going on. To me, the most important thing, and I think I stated it as earlier, is I generally want a mediator who has expertise in this area of law. Having said that, I find, some of the retired judges that I have used unbelievably great, even
Hmm.
though they didn't specialize in this area because judges do everything. I mean, they're just so smart that they just get it.
Sure, sure. And then for you, you will be asked to be a mediator, and you would take that on in the midst of your busy litigation practice if you found the case interesting, or if you
Oh,
maybe.
I always take them on because I love
Okay.
it. I find it so interesting to see both
Ah.
sides at work.
Oh, okay.
Um, from just a work perspective, it's when I say an easy case, I mean that it's in and it's out, right? Like litigation goes on for
Sure,
years. So
sure.
I
I get
love
it.
a case where I read the briefs, I think about it, I make some notes, and I go in for
Ah,
a day and I try my absolute best to solve the case. If I
ah.
solve it, I'm so happy. If I don't solve it, I think of it as a personal failure. But
Okay.
but
Yeah.
beyond that, I'm in and I'm out, and frankly, I get paid. Whereas litigation,
Sure.
eh, goes on for a long, long time. And I think, the mediator's perspective, I think it helps me as a lawyer because I've seen it,
Oh.
what's going on in different rooms, and it, the human dynamics of it is just unbelievable.
Oh, fantastic. So it's in a way it's sort of professional development for you
Yeah.
to have those mediation days. Oh, that's really interesting. So in your experience, what are some ways in which you've seen advisors, be it a banker, a portfolio manager, chartered accountant, can be helpful to clients? Have you heard of ways in which, or are they best advised just to keep out of it, just keep their opinions to themselves?
I think I don't think it's a matter of necessarily being helpful or unhelpful, but rather to take good notes, to be aware of the issues, to be aware if someone new is coming in, how they were referred to you. Are you letting that other person in the room?
Hmm.
Is this an unusual situation where you've got to be, where you should be worried about it? Because we can get your file produced pursuant to a court order, just like we get the medical files, the lawyer's files, we can get the accountant's files, we can get the financial planner's files, and they have
Hmm.
to produce them. And, just like you and I and everybody in their professional life, they want their file to look good.
Hmm.
So, it's always good to take notes, to
Yep.
document what you have done, to be honest, to be candid, to be taking instructions from the right person. I think that's
Right.
that's really where people get in trouble.
Hmm.
Planners, accountants, lawyers, anybody, right? Like, you know,
Remember who your client is.
yeah, like I can say, for me, I often have a group of clients. So I often have, all the siblings or all the nieces and nephews. And of course, I often have one person as the liaison because I can't speak to
Hmm.
seven people all the time. But for important decisions, I make sure that I'm speaking to all the seven people because that's when professionals get sued.
Right.
And for a financial planner, if they're constantly, or not even constantly, if they're taking instructions where, whether over the phone, I know you can't take trading instructions like that usually, but from, it doesn't matter, from the daughter, from the wife, from the husband, from someone who's not your client, that should clue you into why isn't that person calling me? Because all my other clients call me. So why is this person not calling me or not coming in and they're sending, or there's a proxy? Well, maybe these aren't their instructions. And so, you won't be able to stand behind, when someone wants to set aside a, life insurance designation or an RRSP designation, you won't be able to stand up, I don't want to say in court because it doesn't get that far, but,
Hmm.
withstand some discussions with the lawyer about, well, did you explain that the RSP was worth, doesn't matter, $1 million, and
Hmm.
that it was going to your son and daughter, and now you've put it to your daughter? Did you understand that? Did you know that? Who did you get those instructions from? That's that's where the planners, accountants, investment people, all these people can really help themselves.
Right. That's excellent. And I recall, Felice, from an earlier conversation that we had, you mentioned texts, and I think that's worth mentioning again. How I think some people might not be aware that those things can be definitely subpoenaed. I think their story you shared with me was that clients say how terrible the texts are that they received from their brother, and then you get a copy of the text that your client sent to the brother, you know? So I think people,
Yeah.
including advisors, need to be aware of that all of that is fair game.
You know, I have to say that texts and emails are a boon to litigation lawyers because we never had that kind of evidence, right? So if someone said to me, well, my brother told me this, and the other side said, no, I told my brother something else, we didn't know. But now we have all this written evidence. As far as texting is concerned, and I'm extremely old-fashioned, like I don't think texting is the relationship between professionals and their clients. So my clients don't text me, and I don't text my clients. That's
Yeah.
we have email for that.
Mm-hmm.
And one thing I say to clients when they come in is, have you been texting the brother, sister, this one, that? Oh, yes, we've been texting. I said, stop right now, because you're just creating evidence, all of which is relevant. And I'm sure it doesn't look good, and it never looks good. It doesn't look good on either side. So, I don't know, obviously, financial advisors, I'm sure, I don't know, a governing body, and if they have rules, and we have rules of professional conduct, but
Mm-hmm.
it's certainly not in our rules of professional conduct that you can't text people. You can, but I would just be very careful. And I
Yes.
also think, like, texting is where you can make a mistake, because people are paying advisors for their expertise, for their advice. It's not like, oh, go to the store and buy me a chocolate bar. Oh, I changed my mind, buy me a bag of chips. Okay, yeah, I'm doing it. And I always think, like, that's where I can make a mistake if I'm responding too quickly. So an
Yes.
email, to me, has more of a formality to it and more
Mm-hmm.
of a pause to it. Whereas a texting is like, oh, we're doing this all day. Oh, sure, you're going to bring your mother to see me. Yeah. Okay. Oh, she can't come. She's not feeling well, but here's my instructions. Like, I don't like, this is not for texting.
Just stop. Yeah. Yeah.
Stop.
Yeah. Very, very interesting. So we've reached the end. This has just been so fascinating. I could talk to you all afternoon, but I will ask you if there's anything that you were hoping to cover in our conversation today that we didn't get to.
I think so. I think we covered a lot of topics. And I think, for financial planners, I think they definitely help their clients. They help their clients understand all kinds of complex things.
Mm-hmm.
And, my advice is really to explain things simply, to make some notes, to make sure that you are taking instructions from your actual client and not somebody else. And just to be aware of some of the issues that we've discussed that end up in litigation, so that it's not that you can prevent yourself from being a witness, but if you are a witness, or if the file is ordered to be produced, that you're proud of the work you've done. You're
Yeah.
proud of what you did, and you think you did, a good, reasonable, timely, ethical job, and fulfilled your duties.
Yeah, that's excellent advice. And the thing is, too, we never ever know when a client or a file will be going to, a court matter, or a dispute. We might think, oh, this is sounding like in conflict, but we don't really know. So, moral of the story is to make sure that every file is well tended, notes up to date, and so on. Well, thank you again, Felice. It's been a pleasure, and all the best. Bye for
Okay,
now.
thank you. This was very interesting for me. I've never done a podcast, so it was lots of fun, and I hope informative for your listeners.
Yes, it is. Thanks very much. Bye.
Thank you.